This piece of paper, this one page, contains 26 words. 26 words that the UK government quietly adopted on the 10th of March this year, 2026. They did not put it before Parliament for a vote. They did not ask the Equality and Human Rights Commission whether it was lawful. And when the Commission gave its verdict anyway, they ignored it. They called it non-statutory guidance, a phrase designed to sound harmless, a phrase designed to make you feel that nothing important had happened. Something very important has happened. And I'm talking to you today not only as a British Hindu, not only as someone who spent decades studying the intersection of faith, law and history. I'm talking to you as a British citizen, and to every British citizen who believes that the law should treat every community equally. And today I'm going to explain, calmly, carefully, and with evidence, exactly why every voter in this country should treat this issue as a priority at the forthcoming election. Let me begin with the definition itself, because I want you to hear it in full. The all-party parliamentary group on British Muslims and an unelected parliamentary working group, not a government body, published in 2018 what it called a definition of Islamophobia. And it reads, Islamophobia is rooted in racism and is a type of racism that targets expressions of Muslimness or perceived Muslimness. 26 words. Let us think for a moment about what those 26 words actually mean in practice, because in law, as in life, what matters is not the intention behind the words, what matters is their effect. Firstly, the word racism. Islam is not a race. This is not a controversial statement, it's a statement of fact. It's recognized in law, in sociology and in theology. There are 1.9 billion Muslims in the world, drawn from every racial group, every continent, every linguistic family on earth. The statement that criticism of Islam is a form of racism conflates, deliberately I would argue, a set of beliefs that anyone can adopt or abandon an ethnic identity that one is born into and actually cannot change. Hindus, Sikhs, Buddhists, Jews, atheists, people of every conceivable racial background have engaged in the scholarly conversation and the critique of Islam for centuries. To call that criticism racism is to misuse the word so fundamentally that it corrodes the legal protections that genuine victims of racism depend upon. Secondly, the phrase expressions of Muslimness or perceived Muslimness. This phrase means that you do not even need to be a Muslim to be impacted upon by this definition. You only need to be perceived as one. This in legal terms is extraordinarily broad. A headscarf, a beard of a particular style, a name, all of these potentially could trigger the definition. What that means in practice is that this is not a narrow, precisely targeted legal instrument. It's a net, and once you cast a net so wide, the question is not who it catches, the question is what it prevents others from saying. And this, my friends, is where the problem begins. The APPG definition, as interpreted and now adopted by the Labour government as non-statutory guidance, has already been used, not hypothetically and not as a warning, but actually used in practice to silence academics, journalists, and community activists who raised legitimate, authentic concerns about specific interpretations of Islamic doctrine. A friend, Professor Stephen Greer, Emeritus Professor of Human Rights at the University of Bristol, and one of the foremost scholars of free speech in Europe, has documented this in exhaustive detail in his recent book. And I want to spend a few moments with the arguments that Professor Greer presented, because he is not a Hindu activist. He is not a political partisan. He's a legal scholar who looked at this definition and concluded that it was incompatible with the rule of law. Professor Greer published his book, Islamophobia and Free Speech, through Academica Press in the United States. He launched it a few weeks ago in London at an event that was hosted by the Free Speech Union. I want to be precise about his credentials, because in the current climate, the first response to any critique of the Islamophobia definition is to question the motivations of the critic. Professor Greer is not questioning whether anti-Muslim discrimination exists. He's not questioning whether British Muslims sometimes face prejudice and hostility. He's asking a different and much more important question. Is the proposed legal remedy proportionate, precise, and equal in its application? And does it meet the standards of international human rights law? His answer, arrived at through meticulous legal scholarship, is no. And he gives 6 reasons. I'm going to go through each one of them because each one of them matters to every person watching this. Not only to Hindus and not only to Sikhs, not only to members of the Hindu community, but to every teacher, every journalist, every student, every citizen who believes in the principle that the law should treat all people and all ideas equally. Point 1. Existing law is already sufficient. The Equality Act 2010 already protects every individual in this country from discrimination on the grounds of their religion or belief. It protects Muslims, it protects Hindus, it protects Sikhs, it protects Christians, it protects atheists. The Racial and Religious Hatred Act 2006 already criminalizes incitement to hatred against religious groups. And so Professor Greer's first point is this: there is no gap in the law that the Islamophobia definition fills. Its only function is to create protection specifically for one religion, protection that the law does not extend to any other faith. That is not equality, that is privilege. That is not equality, that is privilege. And in a country that prides itself on equal treatment before the law, we should be very uncomfortable with that. Point 2. The definition confuses the criticism of a belief system with discrimination against a person. This distinction is fundamental. In a free society, every idea, every political philosophy, every economic theory, every religious doctrine must be open to scrutiny. What the law protects is the person from violence, from discrimination, from hatred directed at them for who they are. It does not and cannot protect the idea, whether that idea is socialism or conservatism, Buddhism or Islam. The moment you extend legal protection to an idea, you have created a blasphemy law. And the Equality and Human Rights Commission itself, the statutory body that exists precisely to enforce the Equalities Act, formally stated in November 2025 that the Islamophobia definition risked creating exactly that, a de facto blasphemy law for one religion in a country that abolished blasphemy law for all religions in 2008. Point 3. The definition is so vague that no ordinary person can know in advance whether their speech falls within it. International human rights law, specifically Article 19.3 of the International Convention on Civil and Political Rights, to which the United Kingdom is a signatory, requires that any restriction on free expression be formulated with, and I quote, sufficient precision to enable individuals to regulate their conduct. The phrase targeting expressions of Muslimness or perceived Muslimness meets no such standard. What is an expression of Muslimness? The definition does not say. The guidance notes do not say. No court has said. This is not a legal standard. It's a political slogan dressed in the language of law. Point 4. The definition has already produced a phenomenon that Professor Greer calls Islamophobia, F-A-U-X-B-I-A, false allegations of Islamophobia deployed as a political weapon. He documents the case of BRISOC, the Bristol University Islamic Society, whose senior members were accused of Islamophobia for examining the documented role of networks within the Muslim community in the facilitation of child sexual exploitation. The allegations were investigated. They were found to be without foundation, but by then, careers had been damaged, research had been suppressed, and the scholars involved had spent years in a process of institutional punishment for asking questions that any serious criminologist was obligated to ask. This is not a hypothetical danger. This is what happens when the word Islamophobia is weaponized without legal precision. Point 5. The definition disproportionately disadvantages other religious and non-religious communities. When you create a specific legal instrument protecting one religion from criticism, you do not simply add protection for that group. You subtract it from all other groups. A Hindu activist who wishes to document the history of temple destruction in India, who wishes to describe the doctrines that justified the persecution of his or her community, who wishes simply to teach their own children their own history, now faces an institutional climate in which doing so may be labelled Islamophobic. This is not a theoretical concern. I will return to it because it's at the heart of everything I wanted to say today. Point 6. The definition, if adopted in law or normalised through guidance, would fail the proportionality test required by international human rights law. Under the ICCPR three-part test, any restriction on free expression must pursue a legitimate aim, and protecting individuals from discrimination is legitimate. But it must also be the least intrusive means of achieving that aim. Since existing law already provides all the protection that is legitimately required, the Islamophobia definition is not necessary. And what is not necessary cannot be proportionate. On the test of international human rights law, it fails. Now I want to turn to what I consider the most fundamental problem with this definition. It is not simply a legal problem, though it is that. It is a moral problem. And I want you to think carefully about what I'm about to say, because it requires all of us to engage honestly with a question that the political class has been unwilling to ask. The Islamophobia definition seeks to protect Muslims from 6 specific forms of harm, to protect them from physical violence and threats, from employment discrimination, from dehumanizing speech and stereotyping, from collective condemnation, the accusation that all Muslims bear responsibility for the actions of some, from the targeting of their religious identity and practice, and from political targeting. These are 6 protections, and I want to ask a straightforward question. Does the classical doctrine of Islam, the doctrine taught in its foundational texts, practiced in its historical jurisprudence, and applied to its legal systems across the Muslim world, extend those same 6 protections to non-Muslims? I'm not asking what individual Muslims believe or how they behave in their daily lives. The vast majority of British Muslims are decent, law-abiding people who would never harm their neighbours. I know this. I work with this community. I respect many within it deeply. I am asking about the doctrine, about what the classical texts say, about what the legal tradition prescribes, because it is the doctrine, not the individual Muslim, that the critics of Islam are criticising. And the distinction matters enormously. Protection from physical violence. The classic Islamic law of qisas, proportional retaliation, does not apply equally to Muslim and non-Muslim victims. The blood money, the diya, payable for a non-Muslim life is, in the dominant Hanafi, Shafi and Hanbali schools, set at a fraction of that payable for a Muslim. This is not a fringe interpretation. This is classical jurisprudence documented by Muslim scholars themselves. Protection from collective condemnation. The Quran, and I cite this not as an attack, but as a matter of scholarly record, contains verses that characterize the polytheist in terms that, if applied to any other group, would meet the definition of dehumanizing speech. Surah At-Tawbah, verse 28, declares the mushrikin, the polytheists, which in the classical interpretive tradition includes Hindus, to be najis, ritually impure, dirty. This is not a medieval invention. This is the text. I'm not saying that all Muslims apply this interpretation. I am saying that the text contains it. And I'm saying that a legal definition which makes it potentially Islamophobic to cite this text, to teach it, to study it, to discuss it, is a definition that has declared one religion's scriptural content to be beyond the reach of the scholarly scrutiny that every other religion's scriptural content routinely receives. Protection of religious identity. The classical Islamic doctrine of Riddah, apostasy, prescribes death for the Muslim who leaves the faith. This is the position of the Hanafi, Maliki, Shafi'i and Hanbali schools of jurisprudence, without exception. The protection of religious identity, which the Islamophobia definition seeks for Muslims, the right to hold and practice their faith without coercion, is a protection that Islam's own legal tradition explicitly withholds from those who were once Muslim and choose to leave. In the 35 countries which retain some form of apostasy law, it is not Hindus, not Sikhs, not Christians, and not secularists who are enforcing it. And yet the moment one says this, the label Islamophobia is available to suppress the statement. The Dhimmi system, the formal legal subordination of non-Muslims in Islamic governance, prescribed that Christians, Jews and pagans living under Islamic rule pay a special tax, the jizya, as the price of being tolerated. They were prohibited from building new places of worship, they were prohibited from riding horses, they were prohibited from carrying weapons, and they were required to wear distinguishing clothing. The Pact of Umar, the foundational document of Dhimmi law, is not a historical curiosity. It's the basis upon which non-Muslims have been governed in Islamic states from the 7th century to the present day in various forms. I put it to you as simply and as directly as I can. The law is being asked to enforce a one-way shield, to protect a belief system that its own doctrine does not extend equally to others. That is not equality before the law. That is the institutionalization of asymmetry. And this is why I say that this is not merely a Hindu issue, or a Sikh issue, or a Jewish issue. This is an issue for every person who believes that the law must apply equally to all. The Christian who wishes to discuss the persecution of Christians in Pakistan, the secularist who wishes to campaign for the rights of ex-Muslims, the feminist who wishes to argue against the doctrinal basis for gender discrimination in Islamic family law, the gay rights activist who wishes to address the theological justification for the criminalization of homosexuality in many Muslim majority states. All of them face an institutional climate made more hostile by this definition. I want to speak now about something more personal, more painful, because I can engage with legal technicalities all day, and so can you. But the real question, the human question, is this: who is harmed by this definition? Whose voice does it silence, and whose history does it erase? Let me tell you about 1971. In March of 1971, the Pakistani military launched what its own commander called Operation Searchlight, in what was then East Pakistan, which is today known as Bangladesh. Over the following 9 months, an estimated 1.5 to 3 million people were killed. 10 million fled as refugees to India. Of those 10 million refugees, scholars estimate that between 80 and 90% were Hindus. Hindus who constituted at that time approximately 20% of the population of East Pakistan. Why were Hindus disproportionately targeted? Because the Pakistani military and its allied Razakar militias, Islamist paramilitaries, used a specific doctrinal framework to justify their violence. They called the Bengali Hindus Kafir, infidels, and they applied to those Kafirs the doctrinal logic of a tradition that had for centuries classified the non-Muslim as a legitimate object of conquest, conversion, or subjugation. The diplomat Archer Blood, the American consul general in Dhaka at the time, sent what became known as the Blood Telegram to Washington, a document that described in contemporaneous diplomatic language the explicitly religious character of the targeting of Hindu civilians. This is not ancient history. The grandchildren and great-grandchildren of those survivors are British citizens today. They live in Leicester, they live in Bradford, they live in London, and they have the same right that every community has, the right to know their own history, the right to teach their children their history, the right to name what happened to their grandparents as what it was, a genocide motivated by religious doctrine. And then there is Kashmir, January the 19th, 1990. On that night, a night now commemorated as Exodus Day by every Kashmiri Pandit Hindu alive, loudspeakers on mosques across the Kashmir Valley broadcast a message. And let me give you the words, because the words matter. Let me give them to you in the original Kashmiri and then in English. Raliv, Saliv, Ya Galiv. Convert to Islam, leave, or die. Asi Gachi Pakistan, Batav Roas de Batanev San. We want Pakistan without the Pandit men, but with the Pandit women. These words were broadcast from houses of worship. They were broadcast to an indigenous community, the Kashmiri Hindu Pandits, who had lived in the Kashmir Valley for more than 5,000 years, the indigenous Hindu habitants of a valley that is one of the great cradles of Sanskrit civilization. Within weeks, between 300,000 and 600,000 of them had fled in the middle of the night, fled leaving behind their homes, their temples, their manuscripts, their ancestral lands. A community that had been 15% of the Kashmir Valley population was reduced within a generation to less than 1%. The slogans were unambiguous. The targeting was religious. The doctrine that animated it, eliminate the kafir from the land of Dar al-Islam, is the same doctrine I described when I spoke of the kafir and the Dhimmi. The same doctrine whose scholarly examination this Islamophobia definition threatens to place beyond the reach of legitimate discourse. I want you to think about what it means in concrete, practical terms. For a Kashmiri Pandit grandmother living in Southall, or Harrow, or Wembley, to sit down with her grandchildren and tell them what happened, to tell them about that night, to explain why the family left, to name the doctrine that sent the perpetrators to the mosque loudspeaker, to name the doctrine that sent the perpetrators of violence to the mosque loudspeakers, and to then discover that the guidance issued by this government, the government she lives under, suggests that describing that doctrine accurately, historically, and truthfully may be Islamophobic. This is not a hypothetical harm. This is the silencing by law of a genocide victim's right to her own history. Now, I want to be very clear about something. I'm not here to advocate hatred of any community. I'm not here to condemn Muslims collectively for the actions of regimes and militias, many of whom were as hostile to liberal secular Muslims as they were to Hindus and Sikhs. The scholars who have documented this history most carefully include Muslim historians themselves. The violence inflicted upon Hindu communities in India over 7 centuries was recorded, first and most meticulously, in the chronicles of Muslim court historians, Hassan Nizami, Ziauddin Barani, Amir Khusro, Juzjani, and the great Firishta, who wrote with evident pride about the destruction of temples and the imposition of Islamic law, citing the doctrinal authorities that gave each act religious sanction. These chronicles are historical records. They are primary sources. They are taught in universities across India, in departments of Islamic studies, in the research programs of the most distinguished academic institutions in the world. The idea that citing them constitutes a form of racism, which is what the Islamophobia definition effectively implies, is an insult to scholarship. It's an insult to history. And above all, it's an insult to the descendants of the people whose suffering those records document. What we need, what my organization, the Dharmic Truth and Reconciliation Council, DTARC, is working to build is not silence. It's not the suppression of any community's history. What we genuinely need is an equal truth and reconciliation process, one modelled on the principles established by the international community after the genocides of the 20th century. The Joinet and Orient-Liga principles adopted by the United Nations, which establish 3 irreducible rights that no state can lawfully extinguish. The right to know the truth about what happened and why. The duty of the state to preserve collective memory. And the right to name those responsible, provided there is corroboration. None of those rights is compatible with a definition that makes the description of religious doctrine legally hazardous. None of those rights is compatible with a government instrument that, in effect, places the history of Hindu, Sikh, Buddhist, and Jain communities, the history of Dharmic peoples, beyond the protection of the law, while simultaneously placing the ideology that justified their persecution under legal protection. DTARC has developed what it calls the 5R framework: research, recognition, remorse, restitution, reconciliation. It's a framework that is explicitly open to all communities, including the Muslim community. If British Muslims have experienced genuine systemic victimhood, that too deserves to be examined rigorously, evidentially, fairly. We are not seeking privilege, we are seeking equality, equal scrutiny, equal acknowledgement, equal protection under a law that applies the same standards to all. I'm now going to speak directly about the forthcoming election, and I'm going to do so without partisan rancour, because what I'm describing is not a party political issue in the narrow sense, though it is a consequence of a specific party's specific decision. It's an issue that any government of any political stripe must be held to account on. It's an issue that any government of any political stripe must be held to account on, because it concerns the foundational principle of equality before the law. The Labour government adopted this non-statutory definition of anti-Muslim hostility on the 10th of March 2026 without bringing it before Parliament for a vote, without commissioning an equality impact assessment covering all religious communities, without seeking formal legal advice from the Equality and Human Rights Commission, which had already in November 2025 told the government that the definition was redundant and risked creating a de facto blasphemy law. They called it non-statutory. Let me explain what that means in practice. It means that it does not have the force of primary legislation, but it means a very great deal more than nothing. Once a government adopts guidance of this kind, universities adopt it in their codes of conduct, employers adopt it in their HR policies, police forces use it as a framework for deciding whether to record a speech act as a non-crime hate incident. Local authorities use it when deciding which community organisations to fund and which to refuse. In the case of Miller versus the College of Policing, the English courts ruled that non-statutory guidance, the hate crime operational guidance, had an unlawful chilling effect on free speech. Non-statutory guidance can suppress speech as effectively as law, while bypassing every democratic safeguard that law requires. This is the thin end of a very large wedge. I would like every voter, Hindu, Sikh, Muslim, Christian, Jewish, secular, of every background, to ask 4 questions of every candidate standing in your constituency at the forthcoming election. 1. Do you support or oppose the March 2026 non-statutory definition of anti-Muslim hostility? Ask them to explain their position. Ask them whether they believe a non-statutory definition that bypasses parliamentary scrutiny is an appropriate mechanism for restricting free expression on matters of religion. Question 2. Do you support an equality impact assessment that covers all religious communities equally, Hindus, Sikhs, Jews, Christians, and the non-religious, as well as Muslims? Because any definition that affects freedom of religious discourse affects all of these communities, and they are all entitled to have their interests considered before such a definition is adopted. Question 3. Do you support the right of Kashmiri Hindu Pandit survivors and British Bangladeshi Hindus to tell their history, including the religious doctrine that motivated the violence they suffered, without risk of institutional sanction? If a candidate cannot give you a clear, unambiguous yes to that question, they do not understand what the Islamophobia definition does in practice. Question 4. Do you commit to supporting a genuine all communities truth and reconciliation process, one that subjects the victimhood claims of all communities, including Muslim communities, to the same rigorous evidential standard? These are not Hindu questions, and these are not communal questions. These are questions about whether this country is governed by the rule of law or by the rule of political convenience. They deserve answers from every candidate of every party. British Hindus are not a small community. We number over 1 million in this country. We are disproportionately represented in the professions, in the sciences, in business, in public service. We vote, we campaign, we give. And on this issue, this single, clear, definable issue, we have a community-wide consensus that transcends every other political difference. We will be watching, and we will be asking the questions, and we will remember the answers. But I would just like to repeat, this is not only our fight. The moment you create a legal instrument that places any ideology beyond scrutiny, you have changed the nature of the society that you live in. You have chosen a path that ends, not quickly and not dramatically, but inevitably in the diminishment of the freedom that every citizen of this country has inherited and should be fiercely determined to pass on. Before I close, I want to say something that I think is often overlooked in this debate. The history of religious violence against the Hindu, Sikh and Buddhist communities of the Indian continent is not a story told by Hindu nationalists or political activists. It's a story told first and foremost by Muslim historians themselves, by Muslim scholars who were present, who served the courts of the conquerors, who wrote in Persian and Arabic, who recorded these events with meticulous precision because in their understanding they were recording the triumph of the faith. Hasan Nizami, who accompanied the campaigns of Qutbuddin Aibak in the early 13th century, recorded the destruction of temples and their replacement with mosques. He gave the doctrinal justification, the elimination of shirk, polytheism, from the lands now governed by Islamic law. Barani, chronicler of the Sultanate of Delhi, recorded with pride the policies of Alauddin Khilji and Muhammad bin Tughlaq, policies designed to reduce the Hindu population to a state of impoverishment and subordination that he described in terms drawn directly from the classical doctrine of the Dhimmi. The great Firishta, Muhammad Qasim Hindu Shah, whose history remains one of the principal primary sources for the Mughal period, recorded the campaigns of Mahmud of Ghazni, of Timur of Babur, documenting the scale of killing and the religious doctrine that sanctioned it. Timur, in his own memoir, recorded that he had the population of Delhi estimated in the hundreds of thousands enslaved or killed. He gave in his own words the doctrinal authority, the obligation to wage jihad against the kafir. These are not Hindu allegations, these are Muslim sources, primary sources held in the libraries of the British Museum, the Bodleian, the India Office Collection, taught in universities, published by Oxford University Press and Cambridge University Press, and cited by Muslim scholars of the highest academic distinction. An Islamophobia definition that makes it legally hazardous to cite these sources is not protecting Muslims. It's protecting a political narrative from the scrutiny of historical truth. And that is something that no honest scholar, or any faith or none, should be willing to accept. I want to close with something that happened very recently, something that happened not in the 7th century, nor the 13th, not in 1971, not in 1990, but last year. on the 22nd of April 2025, just over a year ago, in a green meadow near the town of Pahalgam in the Kashmir Valley, a group of gunmen approached a group of tourists, men, women, families, enjoying the beauty of a place that has been called heaven on earth since the time of the Mughal emperors who first gave it that name. The gunmen separated the tourists into two groups. They asked each man to recite the kalma, the Islamic declaration of faith. Those who could recite it, the Muslims, were allowed to stand aside. Those who could not, the Hindus, the non-Muslims, were shot. 26 people were killed. They were killed not because of anything they had done, and not because of any political opinion they held. They were killed because of what they were, because of who they were, because of the religion they were born into. The attackers were from the Resistance Front, a proxy of Lashkar-e-Taiba, and the doctrine they applied, the separation of the Kafir from the Muslim, the designation of the polytheist as a legitimate target of religiously sanctioned violence, is the same doctrine that has animated persecution on the Indian subcontinent for 1,000 years. It is the doctrine documented by Farishta. It is the doctrine cited by the Razakars who murdered Bengali Hindus in 1971. It's the doctrine broadcast from the mosques of the Kashmir Valley on the night of the 19th of June, 1990. And I want you to understand, under the Islamophobia definition as currently framed, describing this connection, saying in public that the Pahalgam massacre was motivated by the same religious doctrine that has motivated religious persecution of Hindus for a millennium, could and would be characterized as Islamophobic. It could trigger an institutional complaint. It could end a career. It could prevent a university from hosting the lecture. It could prevent a school from teaching the history. I think of the Sikh gurus. I think of Guru Arjan Dev Ji, the fifth guru, who in 1606 was brought before the Mughal Emperor Jahangir. He was tortured for 5 days with hot sand poured upon his body and placed in boiling water for refusing to convert to Islam and for the offence of his scriptural composition. I think of Guru Tegh Bahadur Ji, the ninth guru, who in 1675 walked to his own beheading in Chandni Chowk on the orders of the Muslim ruler Aurangzeb. Why? Because he had chosen to defend the right of the Kashmiri Pandits, yes, the same Kashmiri Hindu Pandits, to practice their faith without forced conversion. I think back to the Sahibzade, the four sons of Guru Gobind Singh Ji, Ajit Singh and Jujhar Singh, who died in battle at Chamkaur, and the two youngest, Zorawar Singh, aged 9, and Fateh Singh, aged 7, who were brought before the Muslim Nawab of Sirhind, Wazir Khan, and who were offered their lives if they would accept Islam. They refused. They were bricked up alive, yes, alive, 2 children, aged 9 and 7, bricked up alive in a wall and left. This is not mythology, this is history, documented history. History that millions of Sikhs carry in their hearts and in their prayers every day. History taught to every Sikh child as the definition of what it means to hold your faith in the face of everything that would compel you to abandon it. And so I ask you, as a parent, as a grandparent, and as a British citizen, I ask you to sit with this one thought. This Labour Party definition could deny Indians, British Indians, whose ancestors lived through these events, whose families carry these wounds to this day, from teaching their own children their own undisputed history of genocide and religious persecution in their own ancestral homeland. Not invented history, not politically constructed grievance, history written down by the perpetrators themselves, history confirmed by every serious scholar who has examined the sources, history that defines who we are, where we come from, and why we are here. The children of Pahalgam's victims deserve to know why their parents died. The grandchildren of the Bengal Genocide, survivors themselves, deserve to know why their grandparents fled. The great-grandchildren of the Kashmiri Hindu Pandits deserve to know why their families were driven into tents in Jammu in the winter of 1990. The descendants of Guru Tegh Bahadur deserve to teach their children why the ninth Guru walked to his death for the right of the Hindu to remain a Hindu. None of that teaching is hatred. All of that teaching is truth. And any law, any definition, any guidance, statutory or non-statutory, that places that truth in jeopardy is not a law that serves justice. It is a law that perpetuates injustice with an official seal. So at the forthcoming election, ask the questions I've given you, demand the answers, and vote for the candidate of whatever party who gives the right ones. And remember this above all: universal human rights must remain universal. The voice of the victim must never be silenced in the name of protecting those who inflicted the wound. I'm Pandit Satish Sharma. I represent the Global Hindu Federation and the Dharmic Truth and Reconciliation Council. And I'm speaking for a community that has waited too long and suffered too much to be silent now. Jai Hind, Sat Sri Akal, and Jai Shri Ram. Om.